Ai tak ke internet tadi. Tanya dia, saya tanya dia pasal dia keluar pasal ceramah pasal ni kan. Jadi dia tak pernah cakap dia. Ialah kita tahu kalau. Oh ya? Oh ya. Aman. Aman sikit. Ya.
Assalamualaikum warahmatullahi wabarakatuh. We would like to acknowledge the presence of our honorable guests and speakers. Ladies and gentlemen, as we are about to begin, please be seated. We will start in about 10 minutes time. Thank you. request that you please switch your mobile phones to silent mode during the duration of the event. This will ensure a disturbance-free and focused environment for everyone. Your cooperation is greatly appreciated. Thank you. Ladies and gentlemen, Assalamualaikum and a very good evening once again to everyone and welcome to the 2024 Basic Structure Doctrine, Reevaluating the Direction of Modern-Day Constitution. Our talk today will surely give us better exposure to the recent developments of constitutional law in Malaysia, as well as enhance our knowledge of basic structure doctrine from different perspectives. Ladies and gentlemen, your presence at this program is greatly appreciated, and we extend our heartfelt gratitude for your attendance. So please remain seated, relax, and enjoy our talk. It is my delight to be your MC tonight for this informative talk. I am Nur Adila binti Syahrir. Before we embark on the substantive discussion of the day, let us observe a moment for the recitation of dua by Brother Muhammad Faris Haikal bin Bunyamin.
Al-Fatiha. Bismillahirrahmanirrahim. Alhamdulillahilladzi bini'matihi tatimmas salihat. Wassalatu wassalamu ala rasulina al-amin wa ala alihi wa sahbihi ajma'in. Ya Allah, Ya Rahman, Ya Rahim. Praise be to the God, the Lord of the world. Peace and blessing be upon our Prophet Muhammad sallallahu alaihi wasallam and his companions, and for those who followed his example to the judgment day. Ya Allah, Ya Fattah, Ya Alim. On this blessed night, in conjunction with our basic structure doctrine talk, we beseech, see, and grateful towards you in favor of all the infinite blessing to us, your humble servant, to live in safe and prosperous life. We seek your blessing for a flawless progress of this event from the beginning till the end. We seek your guidance to steer clear of events that will detrimental the progress of this event. Ya Latif, Ya Rahman, please bless us with your tawfiq and hidayat. Please guide International Islamic University Malaysia to greatness, peace, glory and prosperity in this world and the hereafter. Make us a responsible intellectual. Grant us with a valuable knowledge that will be beneficial to mankind in order to gain your mardatillah. Make us your righteous servant that followed your command and neglect the sinful act. Please forgive us for our wrongdoing. Allahumma ja'alna jama'na hadha jama'an marhuma wa tafarruqana min ba'dihi tafarruqan ma'suma. ولا تجعل اللهم فينا ولا معنا ولا من يتبعنا شكيا ولا مطرودا ولا محروما. ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم والحمد لله رب العالمين.
Thank you, Brother Muhammad Faris Haikal, for the dua recitation. Without further ado, we are pleased to have with us our Deputy Dean of Ahmad Ibrahim Kuliah of Laws, Dr. Muhammad Asmadi bin Abdullah, to deliver the opening remarks. Please welcome.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh, and very good evening. Ladies and gentlemen, honored guests, distinguished speakers, and their participants, it is with great pleasure and immense pride that I stand before you today as the Deputy Dean of Ahmad Ibrahim Kuliah of Laws to extend a warm welcome to every one of you at the 2024 Basic Structure Doctrine Talk. This event, organized by the BSD 2024 committee, is a significant milestone for us as it marks the very first educational talk of the year. It stands as a testament to our commitment to academic excellence and the pursuit of knowledge within the realms of constitutional law. In collaborations with IIM Law Society, ICOL Alumni Wings, the Civil Law Department of ICOL, and the Political Science Students Association, this talk is an embodiment of the collective effort to provide a platform for comprehensive learnings and discourse. As we gather here today, let us acknowledge the primary objectives of this educational talk is to offer students an avenue for the promotions and developments of their knowledge in the field of constitutional law. Beyond the theoretical frameworks presented in our classrooms, this event aims to bring awareness of recent developments in constitutional law in Malaysia. In conclusions, I extend my heartfelt appreciations to the organizing committee, the collaborating entities, and all participants for contributing to the success of this event. I encourage each one of you to actively engage, questions, and absorb the knowledge shared by our esteemed speakers. Let us embark on this intellectual journey together, fostering a spirit of inquiry, critical thinking, and a commitment to excellence. May this event be a source of inspiration for all of us. Thanks you, and I wish you a rewarding and enlightening experience at the 2024 Basic Structure Doctrine Talk. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Muhammad Asmadi, for your insightful opening remarks. Your thoughtful words have set a tone of significance for our talk, and we sincerely appreciate your presence and contribution. Ladies and gentlemen, our agenda today includes insight from honorable speakers whose expertise is unparalleled. Without further ado, allow me to introduce our first speaker. Sir Loman Sharif alias is a partner at Zurafiq and Partners. He holds a Bachelor of Laws First Class from IIUM, a Master of Laws in Commercial Law from Cambridge University, and a postgraduate diploma in Islamic Banking and Finance from IIUM. He was the recipient of the IIUM Best Overall Student Award, Tunku Abdul Rahman Foundation Gold Medal Award, and was a Fellow of Cambridge Commonwealth Society. He currently holds the position of the Co-Deputy Chairperson of the Constitutional Law Committee of the Malaysian Bar Council. Without further ado, it is my distinct honor to invite our first speaker, Sir Loman Sharif alias, to commence the discourse with his sharing on an overview of the basic structure doctrine and its implication on the separation of powers. Sir Loman Sharif, the floor is yours.
Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alameen. Wassalatu wassalamu ala ashrafil anbiya'i was mursalin wa ala alihi wa sahbihi ajma'in. Assalamualaikum warahmatullahi ta'ala wabarakatuh. Thank you for coming tonight. I think it's quite a number tonight. I think this is the probably second and third time I'm talking about basic structure at the university. I'm very happy to see that it is a continuous talk. I think this is an important subject, and I hope I can explain today in better detail so that all of you can understand the implications that it has on our constitution. In particular for today, I will touch on the main doctrine of our constitution or our constitutional law, which is the separation of powers, right? Okay, let me take you a brief history of the basic structure doctrine. Can you see the slides? Yeah. Okay, I think if you can't, I think I will encourage you to come down if you can't. Right? Okay, so let me take you through a bit of the background. Okay, I have about, okay. Now, the doctrine or basic structure originated from India, but I would like to inform you, I think it has been rejected from when the Constitution was enacted by a number of cases in the federal courts and by our eminent Chief Justices in the past. For example, Almarhum Sultan Azlan Shah, Tun Muhammad Sofyan and Tun Abdul Hamid, right? However, this change, there has been a change since 2017 and 2018 when the Federal Court reversed the decision and adopted basic structure. So I would like to take you through why it was rejected and what is the current basic structure doctrine so that you have a better understanding of what is going on and the implications of the basic structure doctrine. Alright, so why was it rejected before? For this, I would like to refer to the case of Loh Kui Chu and remarks by Almarhum Sultan Azlan Shah, who was then the Chief Justice of the Federal Court then. Right? Now, in essence, he lays out the principle of separation of powers, but I think some of you may know this. Let me take you through. Now, every constitution is unique by itself. Right? We have a history of our own, we have a social values of our own, and that is what Raja Azlan Shah was saying. Whatever may be said of other constitutions, they are ultimately of little assistance to us because our constitution now stands in its own right. Okay? And it can never be overridden by extraneous principles of other constitutions. Each country frames its constitutions according to its genius and for the good of its own society. Right? So let me read through. Okay. So Sultan Azlan Shah was saying actually, each constitution has its own merits, and the question whether a law is harsh or unjust is a question of policy to be debated and decided by Parliament, and therefore would not meet for judicial determination. To sustain, it would cut very deeply into the very being of Parliament, into the very basic element of the Constitution itself. Sultan Azlan Shah then continued, the duty of the court, and its only duty is to expound the language of the Act in accordance with the settled rules of construction. Now this is pretty basic. The role of the judge is to expound the law from what is stated in the law itself, what is expressed. Now if we have a problem with the law, those who find fault and with the wisdom or expediency of the impugned act and with the vexatious interference of fundamental rights normally must address themselves to the legislature and not the courts. They have their remedy at the ballot box. Now, this is very important. What it is trying to say is this: when we are not happy with the law, right, the remedy resides in the Parliament, because the Parliament carries our value, the Parliament carries what we want. If we are not happy, what happens is that we can remove the parliamentarians. We can decide not to choose them. That is a basic democratic principle. The court is essentially to look at the law, what is it being expressed, and expound from there. Right? And now, this has been the separation of powers that we have had for decades since the Constitution was enacted. Right? Now, let me take you to the historical timeline for the basic structure doctrine. Now, as I mentioned, from day one, the basic structure doctrine was rejected. Now, there is a major shift in thinking and decisions by the federal courts. In 2017 and 2018, the courts began to adopt and reinforce the basic structure doctrine through cases of Semini Hijaya, Al-Madudo Al-Tenza, Indra Gandhi itself. Right? Now, what happened after that was there is a debate on this PSD, and in fact, it was rejected for a number from 2019 to 21 in the cases of Rovin Jyoti, Maria Chin, Zaidi Kanapia, and Goh Leong Yong. However, in 2022, it was reaffirmed by a unanimous decision in Dinesh Tanafil. Right? Now, what is the basic structure doctrine? I need you to understand there are a few elements in the basic structure doctrine. Now, what it says that our constitution has a basic structure. To me, it is not objectionable. I think every constitution must have its own basic structure. has its own fundamental principle. That far, I think it is still acceptable for me, right? Now, what happened after that is that in this element, only the court has the power to fully determine the scope of the basic structure. Now, any law or constitutional amendment enacted by Parliament, which is contrary to the basic structure as determined by the court, is unconstitutional and shall be invalid. Now, this is what encompasses the doctrine of basic structure. One, the Constitution has a basic structure. Now, the question is, who determines the basic structure? It's the courts, only the courts. Then once the court determines, right, no one can challenge it because that is the basic structure of the Constitution. Now, there are a number of implications to this, right? Let me try to explain in brief. Now, the problem with that is our Constitution does not expressly state what is the basic structure. To us, to some of us, we may say Islam, we may say Raja-Raja, right? But to some people, they may say a different principle. They may agree, for example, fundamental rights of the minorities, for example, right? Now, which is not expressly stated. Not that to say that it is objectionable, but what I'm trying to say here, our Constitution does not have any express provisions to state which provision is part of a basic structure. Right? Now, when basic structure was adopted in India, if you look at India, India has preamble. The Parliament has decided there is a preamble, and from the preamble comes out the principle of basic structure doctrine. And if you look at the cases, those who are expounding basic structure doctrine in Malaysia, they will quote you a number of jurisdictions overseas where they have adopted basic structure. But if you look at some of the cases, for example, in the certain states in the US, Germany, Norway, a number, there are express limitation. Express limitation means it is decided by the Parliament, by the people, what is the basic structure. Now, what we have right now is that the courts fully determine the basic structure. It is therefore, it's not based on any express limitation, but it is determined. There is an implied determination, implied limitation determined by the courts. Sorry. Okay. Now, what this entails is that the determination of basic structure will be in the exclusive jurisdiction. It depends very much on the opinion, views, and inclination of judges. Now, let me take you to the second implication. Now, since the basic structure is determined by the courts, that is why at this present moment, we do not know the scope and extent of basic structure, because it has to be determined case by case basis. We do not know what are the elements of basic structure, and therefore, the law of basic structure to me, it is uncertain, it is undetermined, it is unclear at this point of time. And I mentioned again, it will be subject to the views of judges, opinions, and inclination. And to me, I am saying that this law is arbitrary. Right? Now, the other fundamental aspect is that once the court determines what is a basic structure and declares a law, constitutional amendment made by the Parliament unconstitutional, there is no remedy afforded to other legislative, other bodies of the government, which is the Parliament. Now, I would like to take you to the next slide. If you can recall, in 1988, what happened? We had a constitutional amendment. Before that, the civil courts interfered with the Sharia courts, right? Now, what happened after that? There was an amendment to 1211, which was spearheaded by our Tansi Professor Ahmad Ibrahim. Now, what happened after that? Because there was an issue in the courts, right? There was an issue in the courts. Civil courts have been interfering in Sharia courts. We amended the constitution to say that the federal court has the civil court has its own jurisdiction and the Sharia court has its own jurisdiction. Right? Are you aware of this? Yes. All right. So now, if there had been a basic structure doctrine at that point of time, right, this may not be even be allowed. Right? it fetters, it actually limits the power of the parliament. It is taking away that right and the court is usurping the power of the parliament. So what I'm trying to say, in the future, if we want to amend certain parts, if we have a proper constitutional amendment, right? Constitutional amendment, and the court declared that it is against basic structure, the parliament or even the rakyat now has no more remedy to remedy that part. And this is the major implication of the doctrine of basic structure, right? Now the key thing is that it's under our constitution is Article 159. Some of you may know, Article 159 determines what is the nature of how to amend the constitution. Now, to amend our constitution, we need 2/3 majority to amend some provisions. And in some other provisions, we need the consent of Majlis Raja-Raja. Now, what basic structure doctrine entails is that even though we have 3/4 majority of the parliament and all our Raja-Raja, all the Sultan agree to that amendment, the court still has the right to invalidate that amendment. This is the implication of the basic structure doctrine, right? Now, next, what's the time now? Okay. Now, I won't go, there's a big issue on 1-to-1, maybe I'll touch later. But I would like to generally conclude, I have one more point. This has been debated in the case of Maria Chin. This is, I'm paraphrasing what Yang Ahmad Arif, Rahman Sabli is saying, the impact of basic structure doctrine that all of us need to understand. Now, it would mean, if we adopt basic structure doctrine, that the doctrine of separation of powers prevail over the doctrine of constitutional supremacy. It is the judicial arm of the government and not the federal constitution that is supreme, as the judiciary can override the constitutional mandate by the federal constitution, which vests power in the parliament through Article 1-to-1. Do you follow this? It is saying that the judiciary has become supreme. Article 1-to-1 is then unconstitutional for violating basic structure doctrine. Now this is the impact. Article 1-to-1 is void for being inconsistent with Article 4 of the Federal Constitution. Okay, sorry. I didn't see it. Like, further up. Some more. Okay. I'm paraphrasing what Yang Ahmad Arif, Rahman Sabri is saying in Maria Chin. Next, it is saying that Article 159, which is the amending provision, is redundant and had been formulated in vain by the framers of the Federal Constitution, as Parliament is powerless to amend any basic structure of the Federal Constitution. All post-medical laws are void if they violate by basic structure doctrine. All ouster clauses, with the exception of those enacted pursuant to Article 149, are void not for violating Article 1-to-1, but for violating basic structure doctrine. Okay. Now, let me surmise this, because I have one more point I need to mention, which may affect our Sharia position actually. Now, I need all of us to understand the thing. Now, basic structure doctrine, right, is a doctrine imported overseas, mainly from starting point, which is from India, right? Now, basic structure doctrine, we may all have our own interpretation of basic structure doctrine, right? What is basic structure to the Constitution, right? Now, if we are not happy, we can go to the Parliament and enact laws which we think will follow our values, right? If there is some decision which is not right, or any law which is not right, what we have right now is, if we think that is against the basic structure, we can enact laws which we think should be the basic structure, right? But what is the implication of this basic structure doctrine is that once the court has decided that it is a basic structure doctrine, which is against our values, for example, right? There is no more recourse and remedy that we have to remedy that. And that is my main objection to the basic structure doctrine. Okay, maybe I'll stop for a short while now. Okay, so I would like to pose one question to all of you. Katalah, assuming in the future, all of us think, say for example, that our Sharia court is, we have adequate, we think the judges are of a standard, of a very high standard, and we standard even better probably than the federal court, say for example, right? Or we think they have sufficient, at least sufficient standard, right? And the courts are able to handle this. And we think actually the Sharia court should review the decisions of Majlis Agama, for example, right? Do you think that this is objectionable? Is this acceptable to you? Mungkin tak? Is it possible? Do you think it is something doable? If Sharia courts wants to review the decisions of Majlis Agama, for example, Islamic institutional bodies, Is that amenable? Is that open to all of you? And if no, why, for example? If yes, why? Right? Now, what I'm trying to say is this: if up to a point of time we think the Sharia courts is very capable, and all of us, say for example in this room, agree that they are capable, right, to review the decision of Majlis Ulama, and our Majlis Raja are also agreeable to that, right? Now, why should it be objectionable for the Sharia court to have that power to review the decision of Majlis Agama, for example, or institutional body? Betul tak? Tetapi this basic structure doctrine will not allow that. Right? Now, these has a major implications. That is why, in my fervent view, it is not only that. And I have to tell you, if the rakyat thinks that they want to give power to Sharia courts, right? And if we think it is only affecting the Muslims, right? What is so wrong that the rakyat amends a law to allow that? And our Raja-Raja allows that. Right? Why it is so inhibitive that we cannot do that? Under any democracy, the voice of the rakyat should prevail, should it not? Right? Now, this is the problem of basic structure. It is determined by a number of people rather than by the rakyat. Right? And this is why I have a problem with this basic structure doctrine. To me, it has a wider implication than this as well. The one-to-one amendment done by Prof. Ahmad, I think it will be subject to challenges in the future, because it is about jurisdiction of the Sharia court. Right now, it is still maintained. Right? No one has challenged it yet. Right? But this doctrine, it opens up the floodgate to determine what is the basic structure. Right? If you follow Indira Gandhi, Sharia court is just like an inferior court. I have issue with Indira Gandhi, how they arrived to that conclusion, because they did not take into the historical account. If you look at basic structure doctrine, how it was argued in Canadian cases, for example, the historical part is for pages and pages abound. Right? People deal with history. But in the case of Indira Gandhi, it was there in a few paragraphs. Right? To me, these are not properly ventilated. But even then, I'm still open. But the problem with basic structure doctrine as determined by the court, it becomes definitive. Right? And we have to accept it, and we cannot amend it. That is my problem. In basic structure doctrine, the parliament can amend it and determine what is the basic structure. I'm still open to it. Right? But when you curtail the power of the parliament, that becomes a big problem for me. Right? And that is why this basic structure doctrine, for me, it is what Azlan Shah is saying. The role of the judges is what? Is to expound the law. When the law does not say anything, the law does not stipulate what is expressly basic structure, it is not stated anywhere. And what it should, the role of the court, judiciary, should not be to enact laws to tell what is the basic structure. It is the purview of the parliament. Let the rakyat determines what is the basic structure. Right? Now, by negating or by restricting the rights of the parliament to do this to me has a deleterious effect, a detrimental effect. And that is why I think when we do law, right, this is what I think this is not, I think, covered, I think not stated, not clearly understood, or the implication of this basic structure doctrine. This talk is actually, I had the same talk with Shah Faruqi. I am trying to say, my view is that we can have basic structure, but the express limitation should be set by the parliament. And I've looked at a number of cases. I think a number of jurisdictions, the express limitation is set by the parliament. I don't have that much objection. No, I can accept it. It is amenable for me. But when you restrict the rights of the parliament to remedy an event, and when the courts are the only person who can determine what is the basic structure, for me, there is something fundamentally flawed with the thinking, with the concept, which affects for me the basic structure of our constitution. And that is my main objection to the basic structure doctrine. I hope probably my colleagues can expand further what is happening at the federal courts. Then you can see there are a number of issues that is challenging us. I think today there is another case today, the unilateral conversion. If you read further the decisions, there are something for me which I am not agreeable. Right? There are a number of cases from 2017, 2018. For me, judicial activism taken by the courts, which I am not agreeable to. Right? Some of the decisions, if we are not careful, some must be decided by the parliament. At the end of the day, we are facing challenges of values. If we are not careful, then we are caught, for example, what constitutes gender in the future. Right? And if the courts want to apply equality and the rest, it may not suit our social values, milieu, and environment. And what I'm not saying that the court cannot judge, but if the court wants to judge, it cannot limit the power of the parliament to remedy that scenario. And this basic structure doctrine stand in the way. It is impeding the rights of the public. That is my view. All right, thank you. I will leave it to them. Wabillahi taufiq wal hidayah. Thank you.
Thank you, Sir Luqman Sharif Alias. Our sincere gratitude to Sir for sharing such profound insights on an overview of the basic structure doctrine and its implication on the separation of powers. Your expertise has illuminated our understanding, and we appreciate the knowledge and views that you have brought to this talk. Ladies and gentlemen, as we seamlessly progress in our exploration of key subjects, I am delighted to introduce our second speaker before he brings a wealth of knowledge. Sir Farizal Yusof is a well-known litigator who frequently argues in the High Court and Appellate Courts in Malaysia. With around 20 years of post-qualification experience, Sir Farizal has represented multinational corporations, financial institutions, oil and gas companies, and important individuals in managing their disputes and attending to the preparation of legal documentation. Graduated from IIUM, Sir Farizal is the managing partner of Farizal Zaid and Farizal Aziz and Zaid, a Kuala Lumpur law firm with a focus on litigation, conveyancing, and corporate advisory. As a thinker and opinion leader, Sir Farizal was elected as a member of the Bar Council in 2018 and 2019. Ladies and gentlemen, please join me in extending a warm welcome to Sir Farizal Yusof. Sir Farizal, the floor is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Thank you very much to the MC, Dr. Esmadi, Deputy Dean, Dr. Khairil, my fellow speakers, Saudara Luqman Sharif Alias, and Associate Professor Dr. Mazuki Muhammad, ladies and gentlemen, brothers and sisters, students of IIUM. Brother Luqman has started the talk with and aptly summarized the concept of basic structure doctrine. I don't think I can add more to that, and I hope, ladies and gentlemen, brothers and sisters, you get to grab the basic idea of basic structure doctrine. My topic today is Federal Constitution. Are we sailing through treacherous water? So I've prepared a paper. I will try to read it and explain to you why I say that, why there is a question whether we are sailing through a treacherous water or not. The Federal Constitution stands as focal point of extensive discourse within the Malaysian context, emerging as a subject of considerable contention. So this deliberation spanning legal discourse, political motivation and societal dialogue persists unabated even 6 decades since its inception. The contemporary intensification of these debates is notably marked by the advent of new paradigm of interpretation. Historically, the Federal Constitution has been construed in close proximity to the indigenous milieu, with a discernible reluctance within judiciary to embrace foreign principles employed in the interpretation of constitutional frameworks from other jurisdictions. Brother Luqman stated about what Raja Azlan Shah said in the landmark case of Loh Kui Chun. I think it's quite clear. There have also been strong arguments in support of doctrine of implied restriction on the power of constitutional amendment. Raja Azlan Shah said a short answer to the fallacy of this doctrine is that it concedes to the court a more potent power of constitutional amendment through judicial legislation than the organ formally and clearly chosen by the Constitution for the exercise of the amending power. Alright? And then Raja Azlan Shah also said, whatever may be said of other constitutions, they are ultimately of little assistance to us because our constitution now stands in its own right and it is the end of the wording of our constitution itself that is to be interpreted and applied, and this wording can never be overridden by the extraneous principle of other constitution. Alright? And then I would like to quote what has been said by Wan Sulaiman, the federal court judge in the same case of Loh Kui Chun. Next slide. Another slide. Another slide. The power to amend would not, okay, this is what has been said by Wan Sulaiman. The power to amend would not, in this country, be restricted by anything set out in the preamble, for there is no preamble to our constitution. It seems to me to be clear that if there is to be any restriction to the right to amend any of the fundamental rights set out in Part 2, such restriction would have been set out in one of the various clauses of Article 159 itself. So when 159 doesn't restrict, so you cannot impose any restriction, what more based on extraneous principle adopted from foreign jurisdiction. In 2007, Abdul Hamid FCJ in the case of PP against Kok Wah Kwan rejected the doctrine of separation of power as integral part of the Federal Constitution. His Lordship stated, next slide, a provision of the Constitution cannot be struck out on the ground that it contravenes the doctrine. Similarly, no provision of the law may be struck out as unconstitutional if it is not inconsistent with the Constitution, even though it may be inconsistent with the doctrine. The doctrine is not a provision of the Malaysian Constitution. Note that, doctrine is not the provision of the Constitution, even though no doubt it had influenced the framers of the Malaysian Constitution, just like democracy. The concept of democracy is not stated in the Federal Constitution, but of course it influenced the framers, and the whole Constitution is based on the democracy. The Constitution provides for elections, which is a democratic process. That does not make democracy a provision of the Constitution, in that where any law is undemocratic, it is inconsistent with the Constitution and therefore void. Right? So you cannot import anything which is not expressly stated in the Federal Constitution as a ground to invalidate the constitutional amendment or any law. As commonly acknowledged, the doctrine of separation of power constitutes an integral component of foundational structure established in the landmark case Kesavananda Bharati in India. I think if you read the material, I mean, you can read a lot of articles in the internet. Kesavananda Bharati is the decision of the Supreme Court of India adopted in Malaysia. Nevertheless, it is not noteworthy that until the year 2007, the proposition asserting that any constitutional amendment must not contravene the basic structure had not found acceptance here in Malaysia. And the decision of Loh Koi Chun and Kok Wah Kwan, as I read to you just now, were rendered subsequent to the precedent set by Golaknath and Kesavananda Bharati. Meaning to say that Tun Hamid and also Raja Azlan Shah already considered Kesavananda Bharati and Golaknath. Already considered. There is no issue. They have read the decision in India and they rejected the doctrine nonetheless. Right? Now the new approach. I call it the resurrection of Kesavananda Bharati. Right? In 2010, the federal court in the case of Sivarasa Rasya against Badan Peguam Malaysia had made a frontal attack on the decision by Raja Azlan Shah in Loh Koi Chun. Gopal Sriram, FCJ as he then was, stated in definitive term as follows. Can we go to next slide? Next slide. No, I think you have to go back. Lagi. Alright. Unless sanctioned by the Constitution itself, this is what Gopal Sriram said. Any statute that offends the basic structure may be struck down as unconstitutional. Whether a particular feature is part of basic structure must be worked out on case-by-case basis. Suffice to say that the right guaranteed by Part 2, which are enforceable in the courts, form part of the basic structure of the Federal Constitution. See Kesavananda Bharati against State of Kerala. Resurrection of Kesavananda Bharati, which has been rejected by Raja Azlan Shah, has been rejected by Abdul Hamid FCJ. There are three salient observations that can be made here. First, Sivarasa recognized that there are basic structure of the Federal Constitution, adopting Kesavananda. Secondly, they accepted Kesavananda Bharati's principle. And thirdly, Gopal Sriram said that the basic structure must be worked out in a case-by-case basis. As correctly pointed out by Brother Lukman. How? There is no definitive term. Kesavananda Bharati laid down 8 basic structures. Separation of powers, judicial power, democracy, blah blah blah. 8 features. But Gopal Sriram said that it must be worked out in a case-by-case basis. It is not exhaustive. Right? That lies the problem. In 2017, the Federal Court in the case of Semania Jaya declared that Section 40D of the Land Acquisition Act ultra violates the Constitution and should be struck down on the basis that the power given to 2 assessors under Section 40D to decide on the amount of compensation in land acquisition matter usurping the power of court to decide the reference before it. Right? See, you enact law, give a power to the assessor to evaluate the land acquisition matter. The court struck down the law because the court said that that is usurping the power of court, judicial power. That is Semania Jaya. Semania Jaya also accepted the proposition in Kesavananda and Indira Nehru Gandhi. And the new approach had gained traction in the following judicial decision. In 2018, in Indira Gandhi Muto against Pengarah Jabatan Agama Islam, as explained by Brother Luqman, Zainul Ali FCJ said this: the effect of Article 121(1)(a), next slide, right, is not to oust the jurisdiction of civil court as soon as the subject matter relates to the Islamic religion. Although judicial trend in the past have taken the position that since matter of conversion involves Islamic law and practice, it must follow that the Sharia court must have jurisdiction over such matter to the exclusion of the civil court, this approach was unduly simplistic. It ignores the broader constitutional context in which Article 121(1)(a) is framed, the power of judicial review and of constitutional or statutory interpretation are pivotal constituents of the civil court judicial power. Note here, such power is fundamentally inherent in their constitutional role as the bulwark against unlawful legislation and executive action. As part of the basic structure of the Constitution, it could not be abrogated from the civil courts or conferred upon the Sharia court, whether by constitutional amendment, Act of Parliament or state legislation. Brother Luqman said that Article 1211A will be challenged. I totally agree with that. Because the court is saying Sharia court is akin to an inferior tribunal. While Article 1211A said that the jurisdiction of Sharia court shall have exclusive jurisdiction. And the plethora line of authorities had already suggested that when it comes to Islamic matter, for example conversion, right? For example, any subject matter involving Islamic law, for example fatwa, it is in the domain of Sharia court. But the moment you say that it could not be abrogated from the civil court or conferred upon the Sharia court, whether by constitutional amendment, Act of Parliament or state legislation, we are actually shutting the door. Right? Okay. Sadly, I have to say this, but Rahman said that Indira Gandhi is a landmark, but actually, just recently, in fact, 2 days before, the federal court, sadly, unfortunately, had decided the case of Kittiswaran Kanagaratnam against PP 2024. Today is 10 January 2024. The Honorable Chief Justice succinctly summarized the basic structure doctrine. Can we go to that? Alright. This is part of it, but I will read the substantive part. Number 1. The most recent of this is Nivesh Nair, decided on 2022, which endorsed a case decided nearly 2 weeks before it in Dinesh Thanapal. But the Luqman mentioned Dinesh Thanapal. In light of Nivesh, the minority judgment of this court in both Maria Chin and in Zaidi Kanapia, but the Luqman said Maria Chin, Zaidi Kanapia has a different view. But the Luqman correctly said that. But CJ said, the minority judgment of this court in both Maria Chin and in Zaidi Kanapia and other cases accurately reflect the state of our constitutional law as regards the so-called basic structure doctrine, which is essentially the doctrine of constitutional supremacy and constitutional judicial review in Article 4.1 as complemented by its device of judicial power. Instead of relying on Maria Chin and Zaidi Kanapia, the CJ relied on the minority judgment. Right? Going further. Other judgment of this court which also clarify the scope and extent of judicial power vis-a-vis Article 4 and 1211 include Iki Putra Mubarak. We need to organize another program if we want to discuss Iki Putra Mubarak. SIS Forum against Kerajaan Negeri Selangor, another program. And Wong Shikai and the Government of Malaysia. This judgment explained the concept of judicial review and how it is a powerful component of judicial power, separation of powers and check and balance. All of the above decisions, this is still CJ saying, yeah? All of the above decisions either expressly or impliedly affirm the trilogy judgment of this court in Semania Jaya, Indira Gandhi and Al-Manudo. Our statement of law at this point is to address the respondent's submission, which in addressing the history behind Article 121 appears to have referred to the majority judgment of this court in Public Prosecutor against Kok Wah Kwan, the decision of the Abdul Hamid FCJ as I read just now. Considering that minority judgment in Maria Chin and Zaidi Kanapia in their entirety now, restate the law in light of Nivesh and Dinesh. Okay, dengar betul-betul. We find it necessary to remind everyone that the majority judgment in Kok Wah Kwan has been overruled and is of no precedential value. Accordingly, cases that were decided among similar lines, such as pihak berkuasa negeri Sabah, are in the same vein overruled and do not have any value as precedent. Faham tak? Ke saya semua yang semangat? Ni kalau khatam Quran ni watamat kalimat habis dah tu, watamat habis. Baca doa je. Nanti saya cakap nanti. Seal the point on basic structure. Sorry Brother Luman. There is no argument, no further argument. The decision in Kitiswaran sealed the point, adopting basic structure, make a ruling that Kok Wah Kwan is no longer a good precedent, establishing the principle in minority judgment in Maria Chin and also Zaidi Kanapiang. You can read all this case. Right? The treacherous water. The judiciary recent paradigm shift in Malaysia find its principal foundation in the case of Kesavananda. However, in India, Kesavananda is from India. In India, the doctrine of basic structure has encountered formidable challenges marked by stringent criticism, profound debates and occasional conflicts and skirmishes between the legislative, executive and judicial branches. Dekat India, bergaduh. Professor Julie Jha in the article The Basic Structure Doctrine, Keeper or Halter, states that the doctrine creates judicial supremacy. Bukan saya cakap, Professor Julie Jha cakap. I quote, Kesavananda Bharati did in reality create judicial supremacy. The judiciary was given unrestricted authority to examine executive actions. There is no question that the Supreme Court decision was unclear, and as Granville Austin notes in his seminal book, Working a Democratic Constitution, A History of Indian Experience, unusual happenings occurred in the period leading up to the decision, casting a pall over the entire procedure. Directly say that it creates judicial supremacy. Bukan kita je cakap. Saya tak cakap pun, dia cakap. The culmination of the discord between the branches of government reached its pinnacle with the pronouncement of the Supreme Court of India in the NJSC Act case of 2015. Yang ni penting. It is very important. In this watershed moment, the Supreme Court of India invoked the principle enunciated in Kesavananda, declaring the constitutional amendment Article 124A of Indian Constitution and the National Judicial Appointment Committee Act 2014, duly passed by both houses of parliament, as unconstitutional. Tahu JC? JC tahu? Judicial Appointment Committee. We set a committee, a few members to decide to appoint a judge. We have here in Malaysia Judicial Appointment Committee. Government of India enact the law, amend the constitution to allow the appointment of National Judicial Appointment Committee 2014, because the old regime of appointing judge in India is very strange. They call it the Supreme Court Collegium, whereby the judge will be appointed by another judge. The Supreme Court Collegium is that the Council of Judges, senior judges, will appoint another judge. So there is no check and balance. That is the old system. The government introduced National Judicial Appointment Committee, but it was shut down by Supreme Court of India using Kesavananda Bharati. The court reasoned that these measures run afoul of the basic structure of the Indian Constitution, specifically the sacrosanct principle of the separation of powers. The contention advanced was that the introduction of NJAC by incorporating 3 non-judicial members into the committee was perceived as an executive attempt to interfere and influence judicial appointment. This departure from the traditional system where judges appointed their peers through the Supreme Court Collegium was argued to compromise the foundational doctrine of separation of powers and independence of judiciary. What happened kalau kat Malaysia buat jadi macam tu? Right? And next slide. So this is what Supreme Court said. Given our constitutional history, the established convention, the view of various committees over the last 70 years, and the view of scores of legal luminaries beginning with Mr. Motilal, the truth through with the judiciary has gone, blah blah blah. I hold that the Article 124A as introduced in the Constitution by the Constitution Act 2014 impinges on the independence of the judiciary and in the matter of appointment of judges, which is a foundational and integral part of the independence of the judiciary and alters the basic structure of the Constitution. It is accordingly declared unconstitutional. They stick to the old regime. Judges appoint judges. The decision of NGAC Act case has not been immune to vehement criticism. This is where I say it is a treacherous water. It creates skirmishes. It creates contention. Arun Jaitley, the Finance Minister of India, characterized it as, I like this word, tyranny of the unelected. Tyranny of the unelected. Judges is not elected. Parliamentarian, members of parliament was elected by the people. So, the parliament decide, the representative of the people decide in parliament to do certain things, to enact certain laws, but it was shot down by the unelected person, which is the judge. To quote Arun Jaitley, tyranny of unelected. Abhishek Manu Singhvi, a Congress member, deemed it as sanctification of judicial self-procreation and a naked usurpation of legislative power. Harsh words. Numerous articles published condemning the decision. In 2022, the Vice President of India, Jagdeep Dhankar, Vice President, Timbalan Perdana Menteri lah kalau kat Malaysia, unequivocally asserted that the ruling in NJSC case severely compromised parliamentary sovereignty and disregarded the people's mandate. More recently, in 2023, Jagdeep Dhankar, the Vice President, has extended his critique to the very foundation of the basic structure established in Kesavananda. He posits that the decision in Kesavananda has set a misguided precedent. So you see, in India, they have been debating this. They have been arguing this. The executive branch has been lambasting the judiciary about this decision. And judiciary has taken offense of it. Counter criticism. Is this not treacherous water? I want to sail through this. You see? Kita tak sampai tahap tu lagi. We have not reached that state yet. But there is a precedent. And we want to adopt and resurrect Kesavananda. I want to quote, these debates have escalated beyond the borders of India, finding resonance in other Asian jurisdictions. Hassan Niazi, in his article, Judging Constitutional Amendment, a critique of South Asia's basic structure doctrine, said, there is nothing in the constitutional text of any of the above mentioned countries, which is Pakistan, India, Bangladesh, in South Asia, that could inform the legislature what counts as the basic structure of the constitution, or when, for that matter, the legislature exceeds its authority regarding it. This directly ties into my next point. One of the main concerns raised against judicial review, especially in the contentious debate about enumerated rights, is that it may allow judges to roam free, imposing their own subjective moral view on the will of the people. The basic structure is the manifestation of this nightmare. Interestingly, Hassan Niazi questioned the definition of democracy. Democratic or undemocratic? The court can declare this law is undemocratic, this law is democratic, but what is the yardstick? What is the guideline? Right? Macam Brother Luqman said, if all of us agree that Mahkamah Syariah should be given more power, all of Malaysian citizens one day say that Sharia court should be given more power, and the parliament amend the constitution to that effect. But we are caught under basic structure. But then, what is the definition of the basic structure then, as opposed to the will of people? What he said, listen to this very carefully. Next slide. This is a concept so broad that the judiciary could presumably shoehorn anything and everything under the sun to justify striking down a constitutional amendment. For example, some views say that the Sharia is repugnant to democracy. Would this mean that any constitutional amendment that sought to increase the power of Pakistan Federal Sharia Court would be unconstitutional? Which concept of democracy are we following exactly? Pakistan is a democratic country where Islam is a state religion and enjoys preference over other faiths. Many would view this as an undemocratic feature, but many in Pakistan may not. So which idea of democracy would the judiciary follow? It would seem that the standard would be whatever concept of democracy is favoured by a majority of unelected judges as opposed to the elected representative of the people. Very clear words, right? Sama macam dah dulu bacakan tadi. Exactly. This is what happened. I want to bring your attention to one case, Refah Partisi. Pernah dengar Refah? Refah Party is a political party in Turkey. Bukan Turkey sekarang. Turkey. Refah Party. Refah Partisi indeed provides a poignant illustration of this complexity. What happened? The Turkish Constitutional Court decide to dissolve Refah Party. Dissolve. Hapus, masukkan Refah Party. On the ground of being a center of anti-secular activities and violating the principle of secularism reflects a broad violating the principle of secularism on the ground of activity anti-secular. Refah Party ni Islamic Party. In 1995 general election in Turkey, Refah Party menang majority the election, 158 seats, the biggest party in the parliament, in 1995. But in 1997, Constitutional Court declared Refah Party should be dissolved because violating the principle of secularism. Faham tak? The dissolution of Refah Party, despite its significant electoral success in 1995, raises profound question about the standard applied to safeguard democracy and whether such action align with the essence of people's power, a fundamental tenet of democratic governance. What then is democracy? People have elected 156 seats in parliament. Islamic Party. Constitutional Court cakap, no, dissolve because anti-secular. We don't want to talk into details about the evidence and whatnot, but the principle, because it goes against basic structure of Turkey constitution. That's it. Very alarming. So in Malaysia, one more point. Ada masa lagi sikit. One more point. Kesavananda and NGSC case is about challenge to constitutional amendment. I said to you, Kesavananda challenged the amendment about the property right. NJSC is about Article 124A, the creation of National Judicial Appointment Committee. This is constitutional amendment, yeah. In Malaysia, such challenge on ground of against basic structure, on ground challenge to the constitutional amendment on the ground of basic structure has yet to happen. In most cases, since Semenyih Jaya, the Federal Court decided that certain provision of Parliamentary Acts are unconstitutional and not constitutional amendment. Semenyih Jaya is on Section 40D Land Acquisition Act. Sivarasa Rahsia is on Section 46A of LPA. Dinesh Tanafel is on section 15B of POCA. Zaidi Kanapiah is on section 4 of POCA. Indra Gandhi is on civil court power to judicial review. Kitis Swaran on section 51A of Atip Som. There is no challenge on constitutional amendment. Yet. The question that can be asked is whether the basic structure doctrine can also be utilized to strike down any parliamentary legislation and or executive action and not only constitutional amendment. Anandini Saha in her article, Basic Structure Doctrine, limited to only constitutional amendment, stated that although decision in Indra Gandhi Mutto di India, has limited its application to only constitutional amendment, the concept has been broadened. Same here in Malaysia. However, where the line should be drawn is still unclear. My conclusion: we might be sailing through treacherous water in form of multifaceted nature of ongoing debates. 4 issues. First, the debate on judicial supremacy or overreach. Examining whether BSD fosters judicial supremacy or crosses into judicial overreach is a fundamental discussion. Balancing the judiciary role in upholding constitutional principle with the need to respect the separation of power is crucial. Number 2, compromise of parliamentary sovereignty and people's power. Delving into whether BSD compromise parliamentary sovereignty and the power vested in the people raises significant concerns about the delicate equilibrium between democratic principle and constitutional limitation. Number 3, applicability to ordinary laws and executive action. The extension of the BSD beyond constitutional amendment to include ordinary laws and executive action introduce layers of complexity, prompting reflection on the scope and limits of this doctrine. Otherwise, tak ada limit. Executive action pun you declare unconstitutional because of BSD. Padahal executive action can be declared unconstitutional as against the constitution, as against Article 10, for example, freedom of speech, as against Article 3, for example. But now you can declare the executive action is against basic structure of the constitution. It would never end. And lastly, standard of democracy. Interrogating the standard of democracy in the context of applying the BSD as a critical dimension. We don't want Refah case to happen here. Right? This involves grappling with questions about the compatibility of democratic ideals. Lastly, the overarching question about the interpretation of the federal constitution is whether it should be strictly based on its wording or whether extraneous principles from other constitutions should be considered. Navigate the tension between textualism, nak ikut teks saja ke, and a broader comparative constitutional approach. Wabillahi taufiq wa hidayah. Assalamualaikum warahmatullahi wabarakatuh.
A sincere thank you to Sir Farizal Yusof for the enlightening discourse on federal constitution. Are we sailing through treacherous waters? Your profound insights have added valuable perspective to our informative talk, and we appreciate your sharing. Thank you, Sir Farizal. Ladies and gentlemen, as our journey through insightful discussion continues, it is my honor to introduce our third speaker. Associate Prof. Dr. Marzuki bin Muhammad is an associate professor currently teaching political science at the Kuliah of Islamic Review Knowledge and Human Sciences (IIUM), having attained the culmination of academic excellence with a bachelor's degree in law from IIUM, complemented by a master's degree in political sciences from University Kebangsaan Malaysia, and fortified by Doctor of Philosophy in Political Science and International Relations from Australian National University. Dr. Marzuki is a knowledgeable scholar that has published numerous articles and conducted various research projects relating to social science, politics, and law. Ladies and gentlemen, let us warmly welcome Dr. Marzuki Muhammad. Dr., the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin wassalatu wassalamu ala asyrafil anbiya wal mursalin wa ala alihi wa sahbihi ajma'in. Distinguished guests, brothers and sisters, ladies and gentlemen. First, I would like to thank Ahmad Ibrahim Kuliah of Law and the IU Anglo Student Society for inviting me to speak at this event tonight. Being a former student of this kuliah back in the late 1990s, it is a great honor and privilege for me to address the students and academic members of this kuliah, some of whom are my former lecturers and friends, including Dr. Asmadi, Dr. Khairi here, on such an important and timely topic of basic structure doctrine. This doctrine, which was expounded by Dietrich Conrad, a German scholar, and promoted by Carl Schmitt, a German constitutional lawyer, was subscribed by Indian judges and finally found its way into the Malaysian judiciary through the judgments of the so-called progressive judges. Put simply, the BST refers to an implied limitations on constitutional amendments based on a particular notion that there are certain features of the Constitution that the court regards as fundamental to it and therefore not amenable to any changes. Changing these features will change the identity of the Constitution, which the judges believe it is their constitutional duty to protect. Now, having said this, the most important question to ask is what constitutes the fundamental features of the Constitution that form its basic structure and original identity? To answer this pertinent question, we must travel back in time to understand the historical, social, and political context of our Constitution and Constitution making. Only then can we identify the features that form its basic structure. Now, due to the pluralistic nature of the Malayan society at independence, the making of the Federal Constitution itself was wrought with hard bargaining among different ethnic communities who had different expectations and imaginations of their place in an independent Malaya. The Malays, as the son of the soil, wanted Malaya for the Malays, in which their special position, which they had enjoyed since time immemorial, is protected. Islam is the religion of the Federation. Malay is the sole official and national language, and the Malay rulers enjoy exalted and privileged position as constitutional monarchs. The non-Malays, on the other hand, wanted Malaya for the Malayans, in which they are granted common nationality, treated equally, and free to speak their own language, profess their own religion, and practice their own culture. The framers of our Constitution were therefore faced with a daunting task to strike a fine balance between these competing communal interests and to do justice to all ethnic communities. Of course, justice in this context is a loaded word and a subjective concept. In a deeply divided society, justice for one ethnic community could be regarded as injustice by another ethnic communities. But again, even under these circumstances, it is not totally impossible to reach a compromise, to attain a certain degree of communal justice by carefully crafting a balanced constitution where all ethnic communities may gain something out of the long list of interests that they fought for in return of certain concessions they made to the other ethnic communities. Malaysia's second Prime Minister, Allahyarham Tun Abdul Razak, in his speech at the second reading of the Constitution Amendment Bill on 23rd February 1971, succinctly described this concept that we may call communal justice. He said, and I quote, "The basic provisions relating to the acquisition of citizenship represented a fair and balanced compromise. The same careful and balanced approach runs through the other provision of the Constitution, protecting the legitimate rights of all races in Malaysia. Thus, the provisions relating to the special position of the Malays are balanced by the guaranteed protection of the legitimate interests of the other communities and by the citizenship provisions to which I have referred. The provisions relating to the position of Bahasa Malaysia as the sole official and national language is balanced by the guarantee for the use of the languages of other races other than for official purposes. As regards the provision relating to sovereignty of the rulers, surely no one will disagree that their position should never be open to attack or challenge. Now, Tun Razak further said, the careful and balanced provisions of our Constitution, guaranteeing legitimate interests of all races in Malaysia, are the very foundation upon which this nation exists. Yeah. I would like to repeat this. It is the very foundation upon which this nation exists. To challenge them is to challenge the very principle upon which the nation rests. Now, this means the concept of right should not be only confined to individual rights and liberties, understood in its Western secular liberal fashion, but also communal rights, defined in their own historical and cultural context. To them, to the Malays and non-Malays in this country, at independence, as represented by the leaders of their communities, the Constitution must not only protect their rights as individuals against the excesses of state power, but also defend their rights as a community against the overzealousness of the other ethnic communities in influencing the state to pursue their own ethnic interests. Now, having said that, I'm not saying that this is the only vision of the competing interests in our plural society and how the Constitution was supposed to reconcile those interests. There was an alternative vision to it, seen not from an ethnic but class perspective. The proponents of this class-based perspective, or the radical left, wanted to eliminate all racial differences and treat everybody as equals in their fight against colonialism. They also wanted the Constitution to be crafted along these lines. Unfortunately, this alternative approach to constitution making did not see the light of the day. Nevertheless, its vision of freedom and equality, construed in its secular, socialist fashion, persists until today in the minds of certain segments of Malaysian society, the judges included, I believe, as well as in the core struggle of local organizations and political parties. Now, here lies our problem in identifying the fundamental features that are supposed to form the basic structure of our Constitution. Which features, seen from which perspective, are regarded as fundamental? Is it Part 2 of the Federal Constitution, which provides for individuals' fundamental liberties, or Part 3 of the Federal Constitution and other related provisions which strike a fine balance between competing communal rights? As a matter of fact, the Constitution itself has a built-in mechanisms to protect the provisions on communal rights enshrined in the Constitution from arbitrary amendments by requiring that those provisions can only be amended by 2/3 majority vote in both houses of parliament and consent of the Conference of Rulers. Regarding Article 153, the Federal Constitution entrusted upon the Yang di-Pertuan Agong, not even the legislature, but the Yang di-Pertuan Agong as the head of state, a constitutional duty to protect the special position of the Malays and the natives of Sabah and Sarawak, as well as the legitimate interests of other ethnic communities. As it is the duty of the Yang di-Pertuan Agong to protect this provision, he can tell any Prime Minister who approaches him to get his consent to amend Article 153 that it is his constitutional duty to protect the provision. It is none of the Prime Minister's business to amend it. If this stand is taken by the YDPA, I do not see the possibility of any government, even current government or future government, to obtain the YDPA's consent to amend it. This shows how fundamental this provision is to our constitution. Now, following the decisions of the Indian courts, Malaysian judiciary, as my fellow panelists have explained just now, has invoked BSD and conferred upon itself the power to decide which feature of the constitution are fundamental to constitute BSD. So far, none of our judges consider Article 153 as a fundamental feature of our constitution. Previously, the judges took a more conservative stand on policies of the government, on matters deemed sensitive to Malaysia's multiracial society and the political compromises reached by the communal leaders. Defending Article 153 on the special position of the Malays and the natives of Sabah and Sarawak in the federal constitution, former Lord President Tun Sufyan Hashim, in his book, An Introduction to Constitution of Malaysia 1976. I think this one is one of your reference in the law school. He wrote, protective provisions were written into the Malaysian constitution, not with the intention of pulling back the advancement of the non-indigenous people, but with the intention of securing the advancement of the indigenous people who, through no fault of their own, were and are educationally, socially, and economically less advanced. And the leaders of the non-indigenous people consented to these provisions in return for generous citizenship terms that enable a large number of them to become citizens by a stroke of the pen. This is what we call the social contract, or we call it the constitutional contract, because these terms not only exist in the so-called historical fiction of social contract, but it is become part and parcel of a written constitution. In the same vein, the courts too, taking into consideration the sensitive and potentially inflammable nature of open debates on issue of Bumiputra special privileges and the legitimate interests of other communities, adopted the more restrictive view of the right to freedom of speech and expression if such freedom amounts to questioning the special privileges guaranteed by the Constitution. In 1969, Fan Yuten, former Deputy Secretary General of the Democratic Action Party and the editor of the party's official organ, the Rocket, was charged under the Citizenship Act 1948 for publishing an article questioning Bumiputra's special position. His counsel argued that he was entitled to his right to freedom of speech and expression as guaranteed by the Federal Constitution, and hence he should not be convicted for sedition. I believe his Fan Yuten case happened now, using basic structure doctrine. He will be acquitted. However, delivering the judgment of this case, Justice Abdul Hamid said, and I quote, "One is free to say or express as one pleases, so long as one does not offend the provisions of such law. I will not profess that I am qualified to question the wisdom of Parliament for enacting particular legislation. This, I think, is a matter of the elected representatives to decide whether Malaysia, with her multiracial society, and in view of the composition of her people, there is a need for a legislation in the interest of security to adequately and effectively deal with those words which are expressive of a tendency not to promote peace, but to excite ill will and hostility." Now, there are many cases on the broad categories of national security and economic development that the conservative judges were more inclined to take similar stand with the government in legitimizing legislations that promote national interests. This, however, does not mean that the judges were subservient to the government of the day. There were cases that the courts decided not in favor of the government. It is just that their conservative judicial attitude found resonance with the government's justification in passing those legislations. Now, it was in this context of judicial conservatism that radical view like BSD was vehemently opposed by the previous top judges. In Loh Koi Chun versus Government of Malaysia, the then Federal Court Judge Raja Azlan Shah stated, and my fellow panelists have referred to this case before, there have also been strong arguments in support of the doctrine of implied restrictions on the power of constitutional amendment. A short answer to the fallacy of this doctrine. This is what the late Sultan Azlan Shah said about BSD. The fallacy of this doctrine is that it concedes to the court a more potent power of constitutional amendment through judicial legislation than the organ formally and clearly chosen by the Constitution for the exercise of the amending power. Similarly, former Lord President Tun Sufyan also stood against the basic structure doctrine. In Mark Coding versus Public Prosecutor, he said, and I quote, "As regards the argument that amendments complain of affected the basic structure of the Constitution and are therefore unconstitutional, we have no difficulty in holding that they do not. And it was therefore unnecessary for us to consider the question whether or not Parliament has power to so amend the Constitution as to alter its basic structure, whatever that may be." So the previous judges just brushed aside any attempt to bring BSD into the judicial legal system in our country. However, beginning from the late 2000s, judges with a more progressive judicial attitude were elevated to the superior courts. In the spirit of judicial activism, these judges had no qualms about striking down legislations that they believe were inconsistent with fundamental liberties, which they define as part of the basic structure of the Federal Constitution. I won't read Gopal Sriram in Sivarasa Rasya, which had been referred to by other panelists just now. This means that judges has changed their judicial attitude towards BSD. Now, this changing judicial attitude has opened a judicial space in Malaysia for BSD to take root and develop. My fellow panelists have alluded to the decisions of the court in many cases which signal the reception of BSD in this country, which does not warrant my further explanation. Now, I just would like to stress one point here. What is the point? I believe that the judges were misled into believing that they are the sole protector of the original identity of the Constitution and its grand norm that represents the general will of the people. Is this the right approach? I must say that it is not. Judges, as my two fellow panelists said just now, they are not elected by the people. They are appointed to their positions and are only bound to retire at the age of 66. Nobody can remove them, except by way of cumbersome tribunal, even if they interpret the Constitution contrary to the so-called general will of the people. Should judges therefore confer upon themselves a very wide power to unilaterally decide the future direction of our Constitution by adopting an alien doctrine of BSD? I don't think so. Is that democratic? I don't think so too. Instead, if left unchecked, BSD will turn this country into the dictatorship of the minority, whoever they may be. On this ground, I'm inclined to say that the power to legislate and to decide the future direction of our Constitution should remain in the hands of our legislators. If we are not happy with that, we can boot them out in the next general election, or through whichever means that is allowed by the Constitution. Now let me turn to Islam. Is our Constitution Islamic or secular? Now this is a very interesting point. A very long argument and discourse about whether Malaysia is an Islamic state or secular state. Now there are competing views on this too. In the process of constitution making, the position of Islam in the Federal Constitution was one of the most contentious issues that the framers of our Constitution had to deal with. The Reed Commission, with the exception of Justice Abdul Hamid of Pakistan, was not keen on making Islam as the religion of the Federation. However, it was the political compromise reached by the alliance leaders that Islam, the religion of the Malay majority, finally found its way into Article 3 of the Federal Constitution as the religion of the Federation. The political testament of the alliance, which contains the alliance proposal on the Constitution, stated, I quote, "The religion of Malaysia shall be Islam. The observance of this principle shall not impose any disability on non-Muslim nationals professing and practicing their own religions and, pay attention to this, and shall not imply the state is not a secular state." They put in the negative. Shall not imply the state means Malaysian state, not a secular state. It is interesting to note that although the alliance leaders agreed that Islam being the religion of the Federation does not negate the secularity of the Malaysian state, the word secular could not be found anywhere in the federal constitution. Unlike the Indian constitution, its preamble clearly asserted that India is a secular nation. Now, is Malaysia a secular state then? If it was the intention of the framers of our constitution to make Malaysia a secular state, that intention could have been explicitly stated in the constitution like the framers of the Indian constitution did. Why didn't they do so? My answer is they could not. Why? Because there are features in the federal constitution that negate the contention that Malaysia is a secular state. Our federal constitution allows state funds to be used for Islamic purposes, including Islamic education. The subject of Islamic education is taught in government schools by teachers whose salaries are paid by the government, including lecturers in this university. Islamic bureaucracy, both at the federal and state levels, is part of the government administration. The state legislatures have powers to enact Islamic laws on matters enumerated in the state list, the 9th schedule of the Federal Constitution. All this could have not been done should Malaysia is intended to be a secular state. Neither the traits of French assertive secularism nor American passive secularism can be found in the Federal Constitution of Malaysia. Now this leads us to the next question. Is Malaysia an Islamic state? The answer is not true. There are features in the Federal Constitution that negate the contention that Malaysia is an Islamic state. Our legal system is mainly based on the English common law system, which you are very familiar with, which is secular. Our political system is based on the principles and practices of the Westminster, parliamentary democracy, and constitutional monarchy, which is also secular. It's not based on the concept of imamah or khilafah or theocratic state. No. It is based on the concept of parliamentary democracy, Westminster type of parliamentary democracy, and constitutional monarchy. So, is Malaysia secular or Islamic? The answer is, to me, Malaysia is neither secular nor Islamic. It has the traits of both, making it a hybrid regime. Is this normal? I think students of political science will say that this is normal. None of the scholars of democracy defines Malaysia as a democratic country. At best, Malaysia is described as a hybrid regime which has the traits of both democracy and authoritarianism. No matter how strong the proponents of democracy would want to see Malaysia transits into full-fledged democracy, the hybrid feature of Malaysia as a semi-democracy remains applicable. Now, if Malaysia can function as a semi-democracy, why can't it function as a semi-Islamic or semi-secular country? I don't know, when I say this, probably I'm going against the philosophy of this university, which makes Islamization as its main aim and purpose. But I'm stating the facts. As a political scientist, I cannot invent facts. I have to state the fact as it is. Well, it is easier said than done. The coexistence of Islam and secularism in Malaysia is not a harmonious affair. There are competing forces in Malaysian politics and society that want to pull Malaysia in either direction. In the 1970s through the 1980s, the Islamization race between UMNO and PAS created fear among the secularists that Malaysia would soon turn into a full-fledged Islamic state. They galvanized popular support against Islamization and kept its forces at bay. Now, the Islamization race has lost its steam. Whether fortunately or unfortunately, it has lost its steam. The gradual political openness of the Malaysian political regime since the last 2 decades had emboldened the secular civil society groups to clamor for political and legal reform along the secular liberal lines. This created fear among the Islamists that de-Islamization is underway, and Malaysia soon will turn into a full-fledged secular state. This university was set up when? In the late 1980s. Yeah? With an aim to try to Islamize knowledge. Yeah? We talk about Islamization of knowledge. Then we talk about Islamization of law. We have Almarhum Tan Sri Ahmad Ibrahim. The kuliah was named after him. The sole purpose of this kuliah of law of the International Islamic University Malaysia is to Islamize the law. We have failed. We have failed miserably. I'm sorry. We failed miserably. Yeah? When I heard presentation by our fellow panelists just now, we have a lot of problems. We have a lot of problems. Yeah, which question our existence. Yeah. It questions our own existence. I would say that UIA will be the last bastion of Islamization in this country. But are we living up to the expectation? Yeah. Are we living up to that expectation? We have a long way to go. We have a very long way to go. Now, the Islamist secularist contestations in the political and social realm spill over into the legal sphere. Since the 2000s, the secular groups have initiated strategic litigations to challenge the constitutionality of Islamic laws in this country, which they believe are antithetical to their vision of a secular nation. They cited various reasons to strike down these laws, including for being archaic, anachronistic, and an infringement of basic human rights and fundamental liberties. They also accused the religious bureaucracy in Malaysia of perpetuating religious authoritarianism that ran counter to their imagination of a free, democratic, and secular Malaysia. Their attempts were not successful in the past, mainly due to the prevailing judicial conservatism of the Malaysian judiciary. However, with the advent of VSD and the prevailing judicial activism of the current top judges, including the Chief Justice, and the changing judicial attitude towards human rights and fundamental liberties, the secular forces achieved significant milestones in their struggle to transform Malaysia into a full-fledged secular state. These milestones have been clearly explained by our two panelists here, which does not warrant any further explanations. Suffice to say that the decision of the Federal Court in Iki Putra's case and the pending Nick Ellen's case will determine the future direction of our modern-day constitution. As it is now, it can be safely said that the balance is tilted toward secularism rather than Islamism. Brothers and sisters, ladies and gentlemen, the neither Islamic nor secular nature of Malaysian state provides the fine balance needed to keep the destabilizing forces among the secularists and Islamists at bay. Both will find something, if not everything, in the constitution that suits their interests. Of course, they will not get everything they want. Perhaps that's how life in a plural society meant to be. As long as the state and its institutions maintain this fine balance by not allowing the Malaysian state to transform itself into a full-fledged secular or a full-fledged theocratic Islamic state, there will be order in society. Disruption to this fine balance will lead to chaos and disorder. Therefore, the role of the judges and the judiciary as a state institution is not to strongly subscribe to a particular ideology or doctrine and explicitly express its cardinal principles in their lengthy judgments. In a plural society like Malaysia, their paramount moral and legal duty is to maintain social and political order through their wise judgments. Justice can never be dispensed when there is no order. On this note, I end my speech and I will be delighted to take questions from the floor. Wabillahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Thank you, Dr. Marzuki. A profound appreciation to Dato for delivering a thought-provoking presentation on Islam, human rights, and changing judicial attitude in Malaysia. Your expertise has added a significant dimension to our discourse, and we are grateful for enlightening contribution and sharing from you. Thank you, Dato. Ladies and gentlemen, we have now reached a pivotal segment of our talk, the question and answer session. This is your opportunity to engage directly with our distinguished speakers. If you have a question, kindly raise your hand and our committee will ensure to assist you with the microphone. When posing your question, please state your name and specify which speaker your question is intended for by mentioning their name. Now, without further ado, let us open the floor to your questions.
Hello, my name is Miordan Shifan. I'm a 4th year student. My question is regarding the Article 121A and how the civil courts and the clashing with the Sharia courts have become a problem. Why do you think, in your opinion, was family law in particular the best catalyst for that change in how we separate the powers of the Sharia court and the civil court? Thank you.
Hello. I'd like to seek clarification. Why do you mention just family law on the 121A?
So you mentioned that amongst the spearheads of that particular initiative was Professor Dr. Ahmad Ibrahim himself, and in his writings, he mainly focused on the applications of in family law, such as in the case of Farida Abdullah. So yeah. So that's why I wanted to ask about how it could be one of the, not the only, maybe the main catalyst of that change. Thank you.
I'm not okay. I'm not that clear. I'm not so sure whether that was the catalyst. I think Tan Sri Prof. Ahmad had in mind at that point of time, right? There was too much interference by the civil courts, right? Though a number of these are in the family law matters, and he was a strong advocate of actually upgrading the stature of Sharia courts in general, right? So I think these twin objectives, I think that is what has driven the amendment to 121A, right? But if you look deeper a bit, 121A does not only cover family laws, family matters. It covers the whole range of our Sharia jurisdiction that we have right now, right? So I don't see it that he was looking only from the perspective of family law. Okay,
maybe one of the work of the late professor is on family law, but there are so many other works, there are so many other writings. In fact, Professor Ahmad Ibrahim wrote about the institution of fatwa from pre-Merdeka. He also wrote about the Qadis Court, the development of Islamic Sharia Court, pre-Merdeka, all the Qadis Court, Hukum Kadin Melaka, Undang-Undang 1999, Negeri Perak, and all that is in his work, is in his book, in his writing. So to say that the late Allahyarham Professor take family law as a catalyst for the change for the amendment of 1998, I wouldn't say it is quite accurate in that sense. But yes, it is one of main major feature. But we have no problem and quarrel about family law. Nowadays, there is no quarrel about that. Yes, family law is within the purview of Sharia court, because you can debate or on the definition of personal law, but that is granted. Family law, nikah, cerai also is within the domain of Sharia court. But the contentious point here is on the other things, the aqidah part of it, the fatwa, institution of fatwa, the jurisdiction of Sharia court with regards to the Islamic criminal law, things like that, which also is within the work of Allahyarham Professor Professor Emeritus Ahmad Ibrahim. Wallahu a'lam.
Thank you. Is there any more questions, please?
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Akhil Ibn Razlan, 4-year first semester student, and glad to see you again, Cik Oman. I have, if I be given the permission to ask 2 questions, if possible. Number 1 is that I would love, actually I'm quite interested with the quote of Datuk Mazuki just now, where the purpose of the existence of ICOL is to produce more law graduates, which is Islamic graduate, to, I would say in other words, to dakwah, to Islamize between the civil law and also Islamic law. But nevertheless, we fail miserably. And for example, one of the examples is that in the case of Nia Eileen, where Encik Yusuf Farizal was the counsel in that case, also against one of the IM alumni. I think Encik Yusuf Farizal know who is I'm talking about. Well, which part? I think by mentioning the name, I think everyone knows here, Datuk Malik Imtiaz. So we would like to know whether, from you as an alumni, what do you think that need to be improved more in ICOL in order to enhance this harmonization of Islamic law and civil law itself? That's number 1. And number 2, when throughout this discussion, we talk about the basic structure, in which basic structure prevent us from changing. And when the topic itself for today is about modern day constitution, do you think this basic structure need to be changed in order to in line with the modern day needs? That's my question. Thank you.
Can you forget that? Brother Muhammad, yes. When I say we fail miserably, it doesn't mean that the whole burden or the onus is on us, or on the IUNM. There are other external factors to it. I'm looking at it from the totality. I'm looking at it from the whole system. And when you talk about judges, we have to look at the system itself, the system of appointment of the judges, how judges are promoted. Now we have this judicial appointment commission, like Brother Farizal mentioned about the National Judicial Appointment Committee in India. We have a Judicial Appointments Commission in this country. Who sits on the Judicial Appointment Commission? The Chief Justice or the senior top judges, the President of the Appeals Court, the Chief Justice of Malaya, the Attorney General, and also other members of the GAC. Now, let me say this. At one time, the members of the GAC are all the secularists. I'm sorry to say this. They are secularists. And they are the one who decided who will be promoted or decided who will be appointed as judicial commissioners. No? The entry level to become a High Court judge. First you are appointed as the GACs. And the process is that you have to apply and you have to go to interview. Yeah? And to be interviewed by the panel consisting of the members of the GAC. One person, a senior lawyer, who applied for the post of Judicial Commissioner, he was called for an interview. And he told me in one of my communication with him, when I'm doing my research on the subject, and he told me, what was the question? The question posed to him by the member of the panel is that, is Malaysian constitution Islamic or secular? Yeah. And his answer is that, no, the Malaysian constitution is not secular. And according to him, there was some kind of debate. And what happened? He didn't get a job. Yeah? So, if the judges, they are all filled up by those who espouse secular values, those who embrace secular whatever thinking, what do you expect of their decision? What do you expect of their decision when it comes to matters on Islamic law, the Sharia law? So of course they will look, they have their own ideological bias. Judges are human beings, like all of us, they are human beings. Judges are too. Hakimu buat salah juga, sebab betul ada rayuan. But now the worrying trend now, which I think is quite worrying, they become very ideological. Yeah? I mean, the previous judges, you mentioned about Raja Azlan, Tun Sufyan, I think they're very professional. Not to say that they are Islamic. Not to say that they are Islamist. They are not Islamist, but they are professional. Yeah? They are professional. And I think they have the right thinking. They have the right frame of mind by, looking at law, as it is, by, I think they have a certain degree of wisdom, to look law as, not only the text of law or whatever, doctrines that you want to look at law, but, law has a function in society. Law has its function in society. And if we read the judgments of the previous judges, I think they are wise judges. I think this is missing in our judiciary now. Thank you.
I would like to touch on my code, but before that, I would like to highlight certain things actually. Do you think the appointment of judges must only be made by judges? Do you think that should be the way? Okay. I like to highlight to you, if you want to see how UK appoints their judges, the commission, 50% or maybe a majority are from lay people. Right? Let me read the composition of the commission which appoint judges in UK, right? 6 must be from judicial members, 2 must be from professional members, 5 must be from lay member, and 1 must be non-legally qualified judicial member, for example. Right? So this is see, there is no fixed rule, I think, right, to be judicial. But if we think from judiciary, everything must be from judiciary, right? That is why you want to protect your interests, right? We can have a look at the UK itself. as much as possible, they want to achieve independence. They want to be fair. They do not want to be judiciary only protecting the judiciary. Do you follow me or not? Right? I would like to open your mind. That is why when people want to review the judicial appointments, we can look overseas and see how it's done. Right? But somehow, the argument sometimes tends to be skewed. Right? Okay, now I just like to open your mind to it. But the main point, I think, or three points, I think. One is what we can do from ICO. So I am from here, but I am very I'm very inspired by what Tan Sri Prof Ahmad is doing actually. But from what I'm seeing right now is, I do not know whether you see this as well. There is an erosion of what Prof Ahmad is doing. We are going backwards. I don't want to mention the current case. Let me tell you something, ladies. Now, prior to Merdeka, Islam used to be the law of the land. Betul tak? Have you read that? Right. Now, we have Islamic criminal law, which has been governed. We are governed by it, and whether you realize it or not, we are discriminated. That means a Muslim is persecuted for carrying an action, but non-Muslim doing a similar action is not being persecuted by the state. Do you follow me? Isn't that discrimination? But this discrimination is what we want. It's what Muslims want. We want to be governed by Sharia. Don't you want to be governed by Sharia? And this has been our tradition. Now, I am seeing from the day of Prophet Muhammad, right, until and unless we speak up, we rise up to the occasion, right, one by one is falling down. Let me tell you, in 2021, we have another 200 lawyers, including my brother here, your brother Rizal, Iki Putra. If you're not careful, for example, let me take it up. Do you think we should have an offense for orang berjudi? Right? Now, let me tell you what is the current scenario. If we follow Iki Putra, right? If we follow Iki Putra, the offense of berjudi for Muslim, can it be enacted by the state? Can it be enacted by the state? Tak boleh, betul tak? It's part of criminal law. Betul tak? So who has the right? Who has the right now to enact an offense for berjudi for Muslim? Now it has to go to federal, betul tak? Now let me ask you, does the federal has jurisdiction to commit, to enact law to punish Muslims? Tak ada juga. So what happened? So if we want to prohibit Muslim in Pahang, for example, berjudi di Genting, state law, state legislature has no power, federal has no power. Who has the power? You tell me, who has the power now? If we follow this trend of decision, who has the power to enact these laws? Who? No one, betul tak? Betul tak? And what will happen? This is actually making our religion become personal, no longer enforced by the state. I do not know whether you see this. It's actually there is a pertumbuhan of ideology. And that we are fighting in this world. If we are not careful, we are going to lose all of this. Right? Now this is the problem with Iki Putra. We have highlighted this in 2021. We need to amend. Now I'm proposing, my colleagues and the rest, we all move. And I want from university as well as possible, we move. But what is the problem? Tiba-tiba ada PhD, dia kata tak boleh buat amend. Faham tak? Kita dah buat amendment, tiba-tiba ada some judges say, this is against PhD. Is it correct? Do you think this is right? It cannot be. There is something fundamentally wrong if we cannot have laws which reflect the value of our society. It can go towards anarchy, disorder later on, if we are not mindful and we are not careful. Do you follow me? That is why we must stand up now. Sooner or later, I would like all of you to stand up. We are lawyers. We are clear what we want.
We must move towards preserving our culture and value. And these values and this milieu or environment has been there before the Constitution. And then when somebody knocks you down, somebody dictates you, there is no longer, are you going to just sit down? Are you just going to just do your study? That is why I now need ICO to be part of this activism. We must have realization, we must be educated, we must inform the rest, we must be active. When I was starting the university last time, there was a change of judges. That is why at that time, the university students became active because there was a removal of the Saleh Abbas. But now is another time. We are saying, yes, let's wait for some decision, right? But from 2021, my view is that we have so much regrets. And today we have another decision. We are a number of decisions which are not in favor. I need you to analyze where we are, where we were, and what do you want? Do you want your children not to be governed by Sharia anymore? You ask yourself. You ask yourself. Do you want your children, Islamic law become a personal law? No, it's up to everybody lah. Right? So that, when the question of what, as I call, what is the aspiration that we should have, that is what I thought we from Iconian at least must start this. If I want to tell you, the counter to this, I've been opposing this BSD, right? The other university which is proposing BSD is University Malaya. So when I went for seminar, probably I was the only one or two contrarian view. The rest are for BSD, right? So we must be clear what we want. We must be clear what we want to achieve, what you want out of your children, right? I think maybe too far-fetched for you to think about children, right? I do not know, but I think we are going to be at the crossroad, and this crossroad may be soon, which I need, if possible, from all those from ICO to stand up and be counted. I need you to be counted sooner or later. And that is why the question from the brother just now, my brother just now, what we need from ICO, we ask, it's still possible. We need to start somewhere, right? Just like the Palestinian, you need to persevere, right? You change. There is a system out there you need to challenge, right? And you cannot allow people to impinge your rights, to impinge your freedom. And that is important. And for us, at this juncture, when it is at stake, we must rise to the occasion. Right? That is, I think, that is what I thought. And I call it, this is why a number of times I come here. I'm from the alumni as well. We are from the alumni as well. We would like to push for this. And we would like to see, we would appreciate very much if you can join in. And sooner or later, I do think we need to move. We need to amend the Constitution, and I need the help of each and every one of you to push for a constitutional amendment. Okay, that's all.
Thank you, Dr. Basuki and Sir Lukman. If we can have one last question. Yeah.
Assalamualaikum, Cik Lukman, Cik Yus, Datuk. I'm Ismi. I'm not from UIA. Actually, I'm from UITM. I have only one question actually. Okay, currently, whether we like or not, there are a lot of academic writings agreed with the BDS. And the fundamental reason is because the outer clause. The outer clause. Okay, while it is understandable that BDS lead to uncertainty, the problem is that if the parliament continues to enact the legislations that promote the executive branch's decision is final, how we can address this one?
reflect about the history of these ouster clauses vis-a-vis the PSD, right? Now, when there was a ouster clauses, I think Indira Gandhi, or what's the case before that? That's Jaya. The PSD, the court looked at 1-to-1, right? 1-to-1 is actually judicial power of the civil courts, right? The court, the issue is in relation to ouster clauses. In order to overcome this, the court said actually 1-to-1 is actually the parliament. The word used is very strong. Suborn the judiciary. You know, suborn is a very strong word. It's just like pilfering or this one. That is what the court said, right? Based on the basic structure doctrine, because of this, the court says they departed from the previous one, and now they have the right to decide on the ouster clauses, right? That was the starting point, right? There are 2-3 issues that I want to highlight, right? Now, 2 things, if the court really feels that 1-to-1 suborn the position of the judiciary, right? That means prior to 1-to-1, right, the position on ouster clauses should be respected, right? But the decision prior to 1-to-1, if you look at Pang Cheng Hock, if I'm not mistaken, right, they respect ouster clauses. So that's what I'm saying. It has nothing to do with BSD on ouster clauses. And if you look at the current decision, Robin Jyoti and the rest, right? Now the court is saying, right, at first there was an issue of 1-to-1. Now the court says 1-to-1 doesn't affect the judicial power. Did you understand? What I'm trying to say is the issue on ouster clauses should not depend on basic structure. It's just, to me, it's just a reason to depart, right? I do think the issue of ouster clauses is a valid issue, and I think we can interpret under the current framework. Under the current framework, judicial review, we can look overseas. These are common in every jurisdiction in the world, right? You do not have to use BSD to introduce a whole range which is unrelated to ouster clauses and which affects our social compromise which we have in our constitution. Mainly, for example, right now, what has it to do with Sharia? Right? So that is my. I do think the BSD was a pretext, right? Was a pretext which is, I find, okay, this is my view, right? Which I find inconsistent with some of the argument on ouster clauses. If they really want to exercise because of 1-to-1, go back to decision prior to 1988, but they did not. They did not even go to what was the power of the judiciary prior to 1988. No. They did not follow any cases by 1988, but they just took a stand just to depart. Right? If, from my personal view, if you want to tackle only ouster clauses, I am fine. But now it has become a different kettle of animal. Right? And that is a problem, a bigger problem that we have created. We have opened up a Pandora box. That is from my perspective.
Because in the first place, Kesavananda and GAC, I wish to state again that this is a case, a challenge against constitutional amendment. So if we're talking about ouster clauses, it is a parliamentary act. It's not a constitutional amendment. So how would you adopt a principle in the decision which touches on the constitutional amendment, adopting here to invalidate ouster clauses? As Brother Umar said, it's two different things. Yes, ouster clauses, you can challenge it by way of judicial review, whether it's unreasonable, whether it's irrational, whether it infringes certain express rights under the federal constitution, freedom of movement, freedom of speech. Yes, you have that avenue, you have that remedy of judicial review under public law to apply for to invalidate the ouster clauses, but not BSD, as in the decision of Kesavananda, because it's totally different. That's why I say until now there is no one challenge level against constitutional amendment yet. But we are talking about BSD. All is a challenge on parliamentary enactment act or provisions, right? So yeah, it's a bit you want to use that for other purpose lah. I would say I don't want to conclude any further. Thanks.
Thank you, Sir Luqman and Sir Farizal. Is there any one last and final question? Yes.
Hello, Assalamualaikum. My name is Hakim. I'm a first year student at ICOL. So my question is simple. Again, I am not with BSD, but my question is BSD important to protect the independency of judiciary, as what we all know from the constitutional crisis and the removal of Tun Saleh Abbas? So does BSD is important to protect the judiciary? Thank you.
I don't think so, because constitutionally the judges has the security of tenure in the first place. You cannot remove them just, for example, Chief Justice, you need to do a tribunal to remove, as in the case of even Tun Saleh Abbas. So they have that security of tenure. So you don't have to apply BSD to protect the threat, if there is a threat in the first place, against the judges. But I just conclude that there is ample provision of law, there is ample constitutional protection for the protection of judges, the security of tenure. It is not necessary at all to apply BSD to protect the judges, right? So I think that would be my simple answer.
I agree with Brother Farizal that the independence of the judiciary is not an issue now. It is not an issue. And it doesn't warrant the court to invoke BSD in order to protect its independence, because it's not an issue. It's not like in 1988 or prior to 1988 that the constant crisis between the judiciary and the executive, because at that time, in the 1980s, we have a problem of executive supremacy. That's a problem. And there was a need to protect the independence of the judiciary. But now, we have another problem. We have the problem of judicial supremacy. So I think in a democracy, when you talk about separation of power, you cannot use up the power of other branch. And I think it's very undemocratic for the judiciary to use up the power of the legislature. I think this is wrong. Put it very simple word, it is wrong. Orang Melayu kata tamak kuasa. That is wrong.
I just want to add one more. When Kesavananda was decided, that it is a majoritarian government. Like Dato' Mazuki said, that our concern those days is executive supremacy, because the majority government has been in power for so long, and then there is a pressure against the judiciary. But nowadays it's a different climate altogether, right? So it's a very dynamic politic. So it is there is more reason why we should not apply BSD nowadays. Thank you.
Thank you, Sir Farizal and Dr. Marzuki. Ladies and gentlemen, to express our gratitude for the invaluable contributions of our honorable speakers, I now honorably invite the Deputy Dean of Ahmad Ibrahim College of Law, Dr. Muhammad Asmani bin Abdullah, to present tokens of appreciation. This is a small token of our immense appreciation for the knowledge and insight shared with us today. I now honorably invite our first speaker, Sir Luqman Sharif alias